Good morning, Ms. Bia. Good morning, everybody.
Good morning, Chair.
Is everybody fine in the new year?
We are here, DC Chair.
You are here. Okay, are you ready?
Yes, thank you very much, Chair.
Okay.
This morning we will be dealing with the evidence of
I
Alex
think you
Cole
have a
and
soft voice. You'll have to raise your voice and also make sure the mic, you're not too far away from the mic.
Thank you, Chair.
Yes.
Thank you, Chair. With me, there are some legal representatives of some of the parties that are mentioned in the evidence. If maybe they can place themselves on record.
Yes, let's take care of that. If you are able to do it from where you are, that's acceptable. If not, you can just have to switch on the mic.
Thank you, Chair. Duncan Wild, briefed by Webber Wenzel attorneys for Cabero Advisory Services.
Thank you. I will have to double check whether the transcribers could hear you, because sometimes when the mask is on, when you have got the mask on, they might not be able to. Yeah, maybe just
Thank you,
can
Chair.
just repeat. Yeah.
I'll double. Duncan Wild, briefed by Webber Wenzel, acting for Cabero Advisory Services.
Thank you.
Thank you, Chair. Azerba, instructed by Wandile Ndabambi of ENS attorneys, and we appear for the state time.
Thank you very much. Thank you.
Thank you, Chair. There had been an indication that there might be some issues in relation to the evidence that we intend to present this morning, procedural aspects. I just need to check with my colleagues whether they will be raising any of those issues prior to the start.
You can just press ahead. If and when they want to say something, they know what to do. Yeah, just press ahead, and if and when you reach a point where they have something, they will indicate.
Thank you, Chair. Chair, this morning we are dealing with the evidence related to mining. That's the mining stream, and the evidence specifically deals with Alex Cole and irregularities that relate to Alex Cole, which is a state-owned entity.
As you explain the evidence that will be led, just take into account that the members of the public might not even know what Alex Cole is. Explain what Alex Cole is and what's involved in the evidence that we'll be looking at, so that as the evidence is given, they will follow.
Thank you, Chair. Alex Cole is a state-owned entity that deals in the mining of diamonds in South Africa. It reports to the Department of Public Enterprises, and the name derives from the area where the mining of diamonds was meant to be taking place, and that's in Alexander Bay. So Alex Cole derives from that. The evidence that we will be dealing with came about when there was a whistleblower that came to the commission and indicated with some allegations in relation to the capture of Alex Cole. And the nature of the capture that he indicated was that there was capture in two ways. There was the capture in the form of getting hold of the produce of the mines, which is diamonds. So getting access to that produce. And the other capture that was indicated was in redirecting the purposes of Alex Cole from its main mandate of mining diamonds into mining coal, and thereby positioning it for entities that are linked to the Gupta family to be able to provide coal to Eskom. The minister at the time had agreed with the board in changing the direction of Alex Cole into coal mining as well. but not to be performed in Alexander Bay, which is the place that Alex Coal was created to serve mainly, but the coal was going to be mined in Mpumalanga and all the other areas that are not in Alexander Bay, and thereby redirecting all the focus of Alex Coal and depriving the community that Alex Coal was created partly to serve. This followed the announcement that there were going to be opportunities to serve Eskom by providing coal for them. Now, what happened was that the idea or the aim was to position Gupta companies to provide the coal to Eskom, and there has been evidence that relates to that. So Alex Coal was also being positioned for that. The evidence, that was what the whistleblower indicated, but he also indicated other irregularities that were taking place at Alex Coal. Having received that submission from the whistleblower, then the commission's investigators conducted their own investigation. And the findings that were made, or the conclusion that was drawn, was that the allegations that had been made by the whistleblower could be supported by the evidence that was uncovered by the investigators. So our witnesses will be, this evidence addresses the terms of reference 1.1 and 1.5 of the commission. And in Alexander Bay, there was a land claim that was made by the community of Richtersveld. They succeeded in their land claim. The effect of their success was that they could now have access to the land that had been allocated to Alex Coal for mining. So a consent or an order by consent was taken by the parties to that litigation, which included the government of South Africa, Alex Coal, and the community of Richtersveld, in terms of which it was agreed that there would be a joint venture that would be created that would represent the interests of the community as well as the interests of Alex Coal. And that joint venture would, and part of the agreement was that the interests in the joint venture would be held in the following manner. Alex Coal would have 51% interest and shareholding, and the community would have 49%. So in effect, a joint venture was then created, and the purpose, the agreement was that the community got access to the land mining rights. And Alex Coal, which always had concessions to mine in that area, it had concessions to mine the land and also to mine the ocean. So there was also marine mining. And the result was that in terms of this agreement, the community gets 49% of the share in the joint venture, but they come with the land mining rights. And the Alex Coal gets 51%, and it comes with the marine mining rights. So this joint venture meant that they were going to pool their resources together, so they would share in the benefits, which was good, given that the land available for mining, or the diamonds in the land, had been depleted, whereas the diamonds in the ocean had not been depleted. So it meant that while the community got this victory of being awarded the land that included a mining right, which could also have become a an empty victory because there was very little left to mine. It meant that there was a benefit to the community by the formation of the joint venture and the fact that they were going to share together in the pooled resources. That is the nub of the evidence, but what also came out and what had been explained by the whistleblower was that the joint venture, although it had been established to ensure the interests of the community were guarded, had in fact appointed a contractor, which was not incorrect. They appointed a person or an entity that was going to be tasked with the marketing and sale of all the diamonds that were mined by the PSJV. So that meant that whether it's mined on the land or in the marine, it would go to this entity, and from this entity it would be marketed and sold, and then the proceeds would come to be shared in accordance with the agreement. The allegations that came with the whistleblower indicated that the entity that was awarded the contract of ensuring, of marketing and selling the diamonds on behalf of the community, on behalf of Alex Co, on behalf of the joint venture, the evidence was that that entity was a Gupta-linked entity. So, and their powers were extensive because the miners themselves, neither the miners nor the joint venture could in fact value the diamonds that they were giving to this entity to market and sell. So they would take the raw material and give it to this entity, and only this entity could then determine, this is how much we value these diamonds that you've given to us, and they had no way of double checking that. And then in the selling, what also came out was that there were no proper records to show who the sales were being made to and how much. So there was a lot of disgruntlement that had happened. There was an investigation that was commissioned by the Department of Public Enterprises, and our first witness will be talking to that investigation. We have witnesses that will testify today, that we have scheduled for testifying today. It's two witnesses. It's Mr. Torres, who is the author of the investigation report that was commissioned by the Department of Public Enterprises. And we also have Mr. Gavin Craythorne, who is the whistleblower that approached the commission. We also have other witnesses that we hope to be able to accommodate in the future that will talk to the links in the evidence that was uncovered and tell and put the story all together. One is Jan Decker. He's a forensic accountant, and he conducted an investigation into the valuation process, among other things, and is able to talk to how much the diamonds were in fact undervalued, because his conclusion was that they were being undervalued by the entity. And the other witness is Peter Bishop. He conducted further investigations into the allegations by the whistleblower, and he drew conclusions from that, and he was able to go further than what the whistleblower had done due to the powers given to the commission.
Okay, thank you. Thank you. Are you ready for your first witness to take the oath?
Yes, yes,
Okay,
Chair.
please administer the oath of affirmation.
Please state your full names for the record.
My name is Alberto Torres.
Do you have any objection to taking the prescribed oath?
I don't have.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give you the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated. Yes, you may proceed, Ms. Sabia.
Thank you, Chair. Good morning, Mr. Torres.
Okay. Thank you.
Chair, if the Chair can have in front of him the bundle that is marked Mining Bundle 01.
Is that the bundle you are going to be using at the moment?
Yes.
Okay,
Thank
that's Mining Bundle 01. Right, yes.
Thank you. Mr. Torres, if I can take you, when I refer you to this bundle, I will be talking about the numbering on the left-hand side, where it's written where it's typed in black, and where it says mining. If you turn underneath the flap that is marked 1.1, you'll see that on the first page that you open to, on the left-hand side of your page, it says mining 01001. Can you see that? Okay. When I refer you to a page, I will not say mining 01 or 001. I will say page 1, and that's where I will be taking to. Okay. Thank you. Please look at that page.
Okay.
Are those your full names written there and your ID number?
Yes, it is.
Is that your initial at the bottom?
Pardon?
Your initial,
Signature, that's my signature.
your initials or your full signature?
The initials on page 1,
Yes.
and then I've got my full signature on page 2.
Okay. Do you confirm that this is a document that you prepared
Yes, I do confirm.
and that you deposed to it in front of a commissioner of oaths?
Yes, I do.
And do you confirm the content that it's true to the best of your knowledge?
Yes, I do confirm the contents.
Have you had a chance to go through it just recently in preparation for today?
No, I've had a chance.
Thank you. Chair, with your leave, may I ask that this document that is marked, that is titled Confirmatory Affidavit, appearing on pages 1 and 2, that it be admitted as an exhibit, Exhibit XX 1.1.
Has it got any annexures or not?
It does, Chair.
It does.
Yes.
I see there is another affidavit by Ms. Dineo Petunia Tomo.
Yes.
Is that an annexure to Mr. Torres' affidavit, or is it a separate affidavit?
It's a separate affidavit, Chair.
So where are the annexures to Mr. Torres' affidavit?
In fact, Chair, Mr. Torres, maybe I should take him first through the sections that I wanted to take him, because it's a very short affidavit and it indicates what it is, what its purpose is. So it's titled Confirmatory Affidavit.
Well, before I admit it, I wanted to know whether when I admit it
With
together
the
with its annexures or
Yes.
is not. That's why I'm asking whether it has got annexures.
It's got annexures, Chair. He refers to them
Are
in
they
his
referred to in
character.
the affidavit?
Yes. Yes, they are referred to, Chair, in his affidavit, and they appear from page 5, and they go all the way to page 1079.
Well, I think the problem is that the affidavit doesn't say, for example, in paragraph 4,
Yes.
what annexure the report is. It just refers to the report. Isn't it? That's right.
Yes.
It looks like the report is the only annexure, is that correct?
No, Chair. The report itself has annexures to it.
No. I'm not talking about annexures to the report. I'm talking about annexures to the affidavit, to Mr. Torres' affidavit. It looks like
yes.
the report is the only annexure to Mr. Torres' affidavit. Am I right?
And then includes exhibits. Yes. Yes. Chair.
Yes.
Yes.
then I think Ms. Thomas' affidavit should not have been placed where it is placed, because if it is not an annexure to Mr. Torres' affidavit, and I understand why it should not, it should not come between Mr. Torres' affidavit and annexures to Mr. Torres' affidavit. That's not the right place.
Chair, I concede that. However, it was necessary to do it in this way because her affidavit also confirms the same report. They were working together. And whereas he confirms that he was the lead, she confirms that she was the junior that worked
Yeah,
together.
but it could achieve the same purpose even if it came after the report,
Yes.
isn't it?
Yes, yes, I accept that, Chair.
Because it now comes between the affidavit of Mr. Torres and the annexures and documents or the report which is an annexure to that affidavit, and yet it is not an annexure to his
Itself
affidavit.
an annexure, yes, yes, Chair.
So it may be that it should be maybe you must think about where, are you going to be referring to it during
No,
his
Chair.
evidence?
We will not be referring to it as
Yeah,
evidence
maybe what
only.
you will need to do during the break maybe is to take it out from there and put it
Somewhere
after the
else.
report.
Yes.
And then then the numbering obviously will change. The best thing might be to not to interfere with the numbering, if possible, and have it numbered right at the end or after the report.
We will attend to that, Chair.
Okay, all right. The affidavit of Mr. Albert Torres, which starts at page 1, together with its annexure, namely the final report referred to in paragraph 4 of his affidavit, is admitted and will be marked as exhibit
XX 1.1.
XX1. So exhibit XX1 is Mr. Torres' affidavit together with the report, which is an annexure to the affidavit.
Thank you,
Okay.
Chair. Thank you, Chair. Mr. Torres, if we can go back to page 1,
I
which is,
think you need to move your mic a little towards the center because I don't think,
it doesn't move, so I need to move.
no, it should be possible to move it. Let somebody help you who. See, if you're speaking too far away from it, you can't be heard easily. Okay, all right.
Thank you.
Okay, let's start then.
Mr. Torres, I refer you back on page 1 of your affidavit. Do you confirm that at the time you deposed to this affidavit, you were an executive director at Gobodo Forensics?
Yes, I do.
Please speak closer to the mic. I
Okay.
think there'll be a similar problem. And when you answer, Mr. Torres, please look at the chairperson.
Yeah.
So your neck will be sore, but you'll have to look at me when I ask questions, but look at the chair when you answer. Thank you. Are you still an executive director at Gobodo Forensics?
For Gobodo. I am a director of Gobodo. However, I retired now, but I am still a director at Gobodo. Okay.
Does that mean you are not any executive director anymore?
No, yeah, I'm non-executive.
Yes, but you remain a director.
I remain director.
Yeah, okay.
Thank you. And do you confirm that Gobodo Forensic Audit was instructed by the Department of Public Enterprises to conduct an investigation?
Yes, I do confirm the Department of Public Enterprises appointed us to investigate this particular matter.
And can you explain to us the process that led to your appointment?
Well, we are on the panel for the Department of Public Enterprises. So being on the panel suggests that we have already been appointed based on our technical abilities. So we were requested to submit a quotation for the investigation into the irregularities at the Alexco PSJV entity. And on that basis, we submitted a quotation and we were appointed. Okay.
What was the mandate that you were given?
Well, the mandate, in summary, they wanted us to investigate the relationship, the soured relationship that existed between the contractors on the one hand and the board and executive on the one hand. But there were also concerns raised by the contractors. And these concerns, some of the concerns were also identified as issues that had to be investigated. Okay, so that was.
Okay. And you conducted this investigation. How long were you given to conduct it?
We were appointed in about July 2019. We then had a 3-month window period to complete. So we submitted our report to the Department of Public Enterprises on the 14th of October 2019. So it took us about 3 months.
And how many of you were involved?
Only 2 of us.
Yes.
It was myself and the Neo, Tomo.
Yes. And you produced the report?
Pardon?
You produced the report
Yes,
at the
I produced the
conclusion?
report and I signed it.
Okay, and this is report you produced is the one that appears from page 5.
That's correct. Is the report.
And you were the author of the
I
report?
was the author.
Okay. Thank you very much. Now, if we can go to the report, and we can go, if you can turn to page 43 of the report.
Yes, I am there.
Is this?
Did you say 43?
Yes, Chair.
He may have given, Mr. Torres may have given the gist of their mandate, but I'm sure that in the report, that's one of the things they start with, to say this is our mandate. Maybe it would be good for you to direct him to that, but actually he probably knows it, so that he can just read that into the record.
Yes, thank you very much.
Before you move on.
That is where I was going, Chair, because it's in the paragraphs that appear on that page.
I thought it would be much earlier.
No,
Okay.
before this is the executive summary, Chair. So this is the actual start of
Or you
the
wanted
report.
you wanted to go to the executive summary, or this is the executive summary?
Yes.
Okay, all right.
Yes, thank you,
Okay.
Chair. So,
You can go ahead then.
thank you. Mr. Torres, if you can look at paragraph 2.5.
Yes, I'm there.
Please read that. And is it correct that encapsulates what your mandate was, starting from 2.5?
Okay, can I read it?
Yes.
Yes, that was the mandate.
Okay. So your mandate, if you can start reading the Department of...
The Department of Public Enterprises seeks to appoint a suitably qualified and experienced service provider to investigate the legality of actions taken by the PSJV in the exclusion of the marine mining contractors and make recommendations arising therefrom.
Yes, and if you go on to paragraph 2.6.
2.6, the DPE, which is the Department of Public Enterprises, wishes to establish the cause of the soured relationship between Alexco, RMC, PSJV, and the marine contractors and make recommendations on improvements that can be made.
And paragraph 2.7.
The DPE further requires an investigation to establish whether the board and the executive of the Alexco, RMC, PSJV exercised objective, fair, and transparent processes in the management of the operations.
Is that everything that you were instructed to do?
Yes, but under our purpose and objectives, we actually break it down further.
Yes, we'll get to that.
Okay, but
Thank you.
in summary, that's what we were appointed to do.
Okay, thank you. Now you are talking about the PSJV. What is the PSJV?
The PSJV, I think you alluded to the fact that there was a deed of settlement, that in 2007, a deed of settlement between Alexco on the one hand and government and the community of Richtersveld was made an order of the court, right? Now, in terms of the deed of settlement, an interim board, joint board, had to be appointed, and the board then had to establish a pooling and sharing joint venture, which would be made up of the Richtersveld community on the one hand and Alexco on the other. So they refer to it as a pooling and sharing joint venture. So the abbreviation PSJV refers to the pooling and sharing.
So the Department of Public Enterprises gave you a mandate to investigate issues related to the PSJV.
Yes, the Department of Public Enterprises is the shareholder representative of Alexco. And Alexco was part of the pooling and sharing joint venture.
Yes.
They actually had a majority shareholding.
Yes.
And based on that, the Department of Public Enterprises appointed us.
Okay, thank
Sorry,
you.
Mr. Chair, I must still get used to
Nah, you will
looking
get
at you.
used. You will get used. Okay.
Okay.
Sorry, thank you very much. So they did not only limit your investigation to Alexco issues?
No, our investigation was into the pooling and sharing, because
Yes.
everything that happened that we were investigating, we investigated for that period when the PSJV was already in existence.
Yes, okay.
Sorry, Mr. Chair.
If you can turn to page 45,
45.
that's where you set out the purpose and objectives of the investigation and the report.
Yes, that's correct.
Yes, so can you tell us what those were?
Okay, 3.1. The purpose, that's just background information. The purpose of the report is to inform the Department of Public Enterprises regarding the background to the investigation, our approach to the investigation and procedures performed, any assumptions made and estimates applied, our factual findings in respect of the investigation, and our conclusion and recommendations based upon our factual findings. Paragraph 3.2, the primary objectives of the investigation are to establish the cause of the soured relationship between Alexco, RMC, PSJV, and the marine contractors and make recommendations on improvements that can be made. The second bullet point, to establish whether the board and the executive of the Alexco, RMC, PSJV exercised objective, fair, and transparent processes in the management of Alexco, RMC, PSJV.
Now, you go to paragraph 3.3, and your title there is the focus areas of the preliminary investigation, were as follows. What informed the choice of these areas as the focus areas?
Well, this was actually highlighted by the Department of Public Enterprises, And they are based on the concerns and issues raised by the marine directors to the department. Okay, so it was an attempt by the department to address their concerns as well.
And so these are the focus areas. Can you tell them what they are?
The first bullet point, to investigate the validity of the decision taken by the Alexco RMC PSJV to exclude the 3 marine contractors in 2018 mining services procurement cycle, to investigate the procurement process in the appointment of contractors, in particular, the appointment of a diamond marketing and sales company, to investigate the process followed in the evaluation of diamonds from the mine site to the diamond marketing and sales company officers, to obtain and review the prices of diamonds realized since the appointment of a diamond marketing and sales company, to investigate the alleged failure to comply with the contractual arrangement, giving access to the information relating to sales and marketing of the diamonds to the contractors. To investigate the legality of the cofferdam operations, which allegedly have caused adverse environmental damage, to review all contracts entered into between the PSJV and the marine mining contractors, as well as any other contract forming related to the subject matter of the dispute between the parties, to determine the contract awarding processes and systems are fair, transparent, equitable, with a focus on mining contracting for both land and marine mining contracting, including the appointment of the diamond marketing and sales company. I think this is just a repeat of that. To determine the legality of the cofferdam operations, which currently undertaken at the Alexco RMC PSJV, and make recommendations on the outcome of the investigation.
Thank you. Now, where did these focus areas emanate from? Because these are very detailed.
Again, the Department of Public Enterprises. They gave us our scope and then detailed it for us. Because what we normally do when we do an investigation as well, we have, once we get appointed, we then have a briefing session with our principal, because we don't want misunderstandings. So we make it clear at the briefing session. They will then detail what we need to do. And this was also where we got some of the issues.
Okay, thank you. And if we move to page 49. There you set out the... Are you
getting confused with the numbering, but I've got it. Okay.
Yes. There you set out the approach and the procedures performed.
Yes.
Can you tell us shortly, without reading word for word, what was your approach and the procedure?
Well, essentially what we do is we have a briefing session where we would meet with the client. After that, what we do is we then agree on an implementation plan. And that's where the 3 months came in. This is what we're going to do, and our deadlines for the reporting and all that. After that, it's what we do is collation of documents. We collect all the documents, and once we've collected all the documents, so what we have here is just showing you our procedures. We collect the documents, and what documents we collected, we then review the documents, and then do, if necessary, our interviews and all that. So that's basically the approach that's used.
Now, in this case, where did the briefing take place?
The initial briefing took place at the Department of Public Enterprise, their offices. We met the officials there.
Mm. And where did you get the documents?
The documents, initially the Department of Public Enterprises was going to give us the documents. But Alexco, the PSJV, is situated in Alexander Bay, which is very far. It was then subsequently agreed, because we were not getting the documents, we then liaised directly with the company secretary called Reagan Phillips. And she electronically emailed us documents, which we then used here. And when we did visit the Lexco plant, we were also given documents.
So the person that gave you the documents is the company secretary of the PSJV
That's correct.
to enable you to conduct your investigation,
Pardon?
to enable you to
Yes,
conduct
yes,
your
correct.
investigation. Okay, thank you. If we move ahead to page 60,
Page 60.
Yebo.
On page 60.
Yes. So you say here background information on individuals and entities. You are talking about the entities that you were to investigate.
Yeah, essentially it was Alexco, the joint venture,
Yes.
just a background information on that. And then Scarlet Sky Investments 60 Pty Limited, this is the marketing company. This is the company that was appointed to sell and market the rough diamonds. Okay, so we just gave a background. And also in the background, it's included who the individuals are, their links and so on. Thank you.
Please tell us who the individuals are and what their links are as contained in your report without reading necessarily from the report.
Okay, Daniel Mark Nathan was the director of Scarlet Sky Investments, but he was also the CEO. Hazel Moira Emmon was what you would call a stand-in director, because Scarlet Sky was a shelf company, and she was the second stand-in director. Christian Goos was also a stand-in director. A lot of shelf companies would see his name. So he's also a stand-in director. Then,
A standing director being simply a director who is a director while a company is a shelf company ready to resign once they've sold the company to somebody.
yeah, that's correct, because if you have an incorporated company, you must have a director.
Yes.
So that's,
Yeah.
so
But
you,
basically at that time, the company is not doing anything.
yes, yes.
Yeah, okay.
You're right, Mr. Chair. And then you had Kesavan Govender, who became a director in 2015. And then you had Kubentharan Mudli, who was appointed at the same time that Daniel Nathan was appointed, a director. And he subsequently resigned on the 5th of November 2015.
Yes.
Okay, so those are the four directors.
And you can continue with what you were describing there, because you were describing the parties.
If I can just read in 8.24, there have been allegations that Kubentharan Mudli was close to Salim Essa of Trillion. Okay, so and then we did a Google search, and then found that there was a formal search seizure in storage facility by the State Capture Commission. In the same court, Mudli had requested the court to interdict the Zondo Commission and deny them access to his documentation and other important personal items, including jewelry and cash that are in the care of Wayne Ryan Becker at his storage facility, Knox Titanium Vaults, which is in Senton. It appears that Mudli's name has been mentioned many times at the Zondo Commission. There are allegations that Mudli assisted Trillion Capital to loot Eskom and help the Guptas with 10 million to buy Optimum Mine and had a hand in the Mediosa contract in the Northwest.
So this was the case at the time that you were preparing this report?
This was the case. What we normally do as well is just to get background information on the individuals that we are dealing with, so that we have a better perspective of what's happening.
What else are you saying here in relation to Mudli?
On paragraph 8.26, the available information suggests that Mudli was the former advisor of the then Mineral Resources Minister, Mosabenzi Zwane. Zwane was appointed to former President Jacob's cabinet in or about September 2015. We note that Moodley resigned from SSI, which is Scarlet Sky Investments, on 5 November 2015. This is soon after Zwane was appointed to the cabinet.
Now, just for my own sake of understanding, did Moodley become an advisor of Minister Zwane after he left, he resigned, or before he joined?
It was before he resigned. Because he resigned in November, and he was appointed in September, if I'm correct, yeah.
Oh, because you are mentioning the appointment of the minister,
Of the minister.
as having been in September. So I'm just trying to get clarity whether you are saying Moodley started, or rather became a advisor after he resigned, after Moodley resigned from SSI, or was he an advisor prior to Minister Zwane becoming a minister? Because
I don't
your
mention
sentence says the information suggests that Moodley was the former advisor of then minister. So I'm not sure whether is a former advisor is what you wanted to say, or when you say was a former advisor, you meant he was an advisor prior to the minister being appointed.
Okay, I'm with you. No, when Zwane was appointed, okay, Moodley was still a director of SSI. As soon as Zwane was appointed in September 2015. So why I'm saying former, it's a former now. Currently speaking, it's former. So he resigned in November. Now I can't remember whether he became an advisor in September or after he had resigned, unfortunately.
No, that's fine. I just needed to understand whether he was former then or if he is former now.
It's former now.
All right, thank you very much. You mentioned another character in paragraph 8.2.7.
We found that Zarina Kellerman, a lawyer, was also one of 3 individuals appointed to advise Zwane. The 3 advisors included, in addition to Moodley and Kellerman, Malcolm Mabaso. The information in our possession suggests that Kellerman purportedly conducted a due diligence on SSI after they were appointed by the PSJV.
Okay, you can leave it there for now. We'll continue with that train of thought
Okay.
when we get to the relevant part. And on 8.2.8, you explain the structure.
Yeah, the structure was essentially Daniel Nathan Trading owned 40% of the business and was represented by Daniel Nathan. 60% was owned by Commodore, represented by Moodley. So this gave so in terms of the black empowerment structure, there was a majority shareholding, black shareholding.
Okay. You can now turn to page 64. This is where you're dealing with the review of agreements, and you start by the deed of settlement between the Richterveld Mining Company and Alex Co. and the government of the Republic of South Africa.
The deed of settlement was, it was an agreement between Alexco on the one hand and government on the one, and also the agreement of and also the Richtersveld Mining Company. Now, the Richtersveld Mining Company was the company that was owned by the local community. Now, in 2007, the court declared the deed of settlement a court order. The deed of settlement deals with a number of issues, deals with the issue of the mining rights, environmental issues. It deals with the way in which the company will be governed. It also, there's a paragraph that stipulates that an interim joint board must be appointed. The interim joint board would then form a pooling and sharing joint venture. But also very important, because the next agreement called the unanimous resolution The interim joint board had to formulate an interim, what they call a unanimous resolution. The unanimous resolution is, in a sense, a governance framework, because it speaks to your subcommittees, what subcommittees there should be. It also alludes to procurement issues, in a sense. So that was important, just to establish the PSJV and give it a governance framework. So the deed of settlement and the unanimous resolution should be seen, together.
And what did the unanimous resolution say?
Well, the first thing that they had to do in terms of the unanimous resolution is to form the pooling and sharing joint venture, the establishment of that. Okay.
And how do we know what were the terms?
The terms in the share, okay, just hold on. When you say the terms of the unanimous resolution.
Yes.
The deed of settlement refers to that a unanimous resolution should be formulated. So those are the terms. The terms come directly from the deed of settlement.
Mm-hmm. And it also, the deed of settlement also says how the formation of the JV is going to happen, and also to give effect to the agreement in terms of the ownership and the shareholding.
Yes. I think if you look at paragraph 9.1.9, it says here clause 8.4.5 stipulates that the members of the IJB, which is the interim joint board, must, before the unanimous resolution can take effect, refer the unanimous resolution to the principles for unconditional. So they then did the unanimous resolution, but got agreement from the principals. That is the government and Alexco. Okay.
Yes. So this involved the government of South Africa. From the time that the joint venture was contemplated, the government was a party to that arrangement.
Yes, because they are in effect the shareholder of Alexco, and also because they have a 51% shareholding in the joint venture. They're also a shareholder in the joint venture, pooling and sharing joint venture.
Okay. You move on and you start dealing with the agreement that was concluded by the JV and SSI. On the next page, 66.
66.
That's where you then move on to speak to that.
An agreement was signed and completed between the PSJV and SSI. SSI was appointed specifically to market, value, sell, and for the beneficiation of diamonds. Now, the agreement was signed by Daniel Nathan, representing the SSI, Scarlet Sky, and then Mervyn Carstens, who was the CEO at the time, Mr. Chair. He represented the PSJV and signed the agreement. The agreement actually stipulates what should be done. For example, it stipulates the type of pricing model that they should have. An auction sale should be conducted in order to sell. They also stipulated the way in which the diamond should be sold. They gave a breakdown. For example, 10% had to be sold to the state diamond trader for beneficiation purposes. Another 5% had to be sold to a local company, also for beneficiation purposes. And then 85% had to be sold to an auction sale. These were key elements in the agreement. Okay. And then it also speaks to the commission that has to be paid, a handling fee, which was 1.5% at that stage. Okay.
Okay. And this contract was signed it's in paragraph 9.3.3.
It was signed on 4th March 2015.
Yes. And then you move on the next page, you talk about a second agreement.
Yes, there was a second agreement. The first appointment was a 3-year appointment. So they were appointed at the beginning of 2015, SSI. But sometime in 2016, a new procurement process was started for the selling and marketing of the diamonds. Nobody can explain why, because the term had not expired yet. But they were appointed, so this agreement relates to that. It's essentially the same, but there are a few differences. For example, the first agreement was a 3-year duration period. The second agreement, the duration period was extended to 5 years, which was quite a long time, you know. And also there were key issues. For example, the 5% that had to be sold to the they had to be sold locally was excluded from this agreement. Okay, so essentially.
Okay. We'll go into more detail later on in your evidence as to what your findings were, because at this stage you're talking about what documents,
Okay.
contracts you reviewed. So you don't have to go into a whole lot of detail at this stage.
Okay.
But later on, you'll tell us what you discovered, yes, if you made any adverse findings and what those were and what informed that. Okay. The next agreement you looked at, you refer to on page 69. So you can tell us briefly.
Okay. This is paragraph 9.5. This is agreement to appoint the shallow water and beach marine contractors. Now, it specifically relates to, there are two differences. The shallow, there were two agreements. The one was, it's called, in fact, it's one agreement, but there are different types of marine mining. You have your beach mining activity, and then you have your shallow water activity. So it deals with those miners here. So it's just your standard clauses where, you know, what has to be, what are the obligations of the contractor on the one end, the obligations of the principal on the other end, but also the way in which payment will be done, the proceeds of the mining activity.
Okay. Now you move on page 10 to speak to about the PSJV coffer dam operations. What is a
Did you say
coffer dam?
page 10?
Oh, my apologies. It's on page 71 and it's item 10.
Chair was also.
Yes. My apologies. Thank you, Chair.
Coffer dam operations. The coffer dam operations, I'm not a technical person, Chair, so but I had to find out what this was. The coffer dam operations essentially take place where beach mining activity takes place. It's on the shore. So what they do is they build a coffer dam wall, and within the coffer dam wall, they would have a machine digging the gravel from this. So the coffer dam would avoid the transport of water. Now, coffer dam operations can be damaging to the environment. It depends what you are using. So the environmental management plan that the PSJV had only included the coffer dam building with sand. So, but they started using boulders and rocks to build the coffer dam. Now once you start, that's a listed activity. In terms of the Environmental Act, it damages the environment, damages the ecosystem, and this was an issue, a contentious issue. So it was one of the issues raised by the contractors, and we looked at it. And we found that, yes, they had used boulders and rocks to build the coffer dam. According to them, they stopped using sand because the tidal waves in South Africa are very strong, and they continuously had to rebuild the dams. Be that as it may, you need special permission to use boulders and rocks. Now, they
Mr.
did
Torres?
use it.
Sorry, I just need to stop you because you keep saying they.
Oh, sorry,
So you can
the
continue.
PSJV
Yes.
continued to use boulders and rocks. They were reported to the authorities, and by their own admission, they admitted that they had used listed activity because they submitted an application called a 24G application. 24G in terms of, I think, the NEMA, the Environmental Act. Now, once you submit a 24G application, it's an admission that you've done wrong, and you want this wrong rectified. Okay, so the complaints by the contractors were valid.
And what were your findings in that regard? Because this is one of the issues that you did identify as your focus areas.
Okay. Initially they denied that they had used boulders and rocks. But I mean, by their own admission, what we found was that they had then applied to the department for permission. There was a public hearing, because you need to have a public hearing, the public has to make its input. We could find no adverse comments at the public hearing about this. However, there was only one, what we found that they then received, they had to submit a new environmental management plan, which would then include the use of boulders. They had submitted that. The department didn't approve it as yet by the time that we were doing the investigation, because they were still waiting for a financial plan from the PSJV. Now, the financial plan is quite key, because when you do the rehabilitation, you need a financial plan. But what we found was that you could find no evidence that they had used boulders and rocks. And we had an interview with the executive management, and they were saying, no, we have rehabilitated the land. And that is why you won't see it there. Now, you can't just rehabilitate an environment in a vacuum. There's a process that happens. You have to inform the department, environmental department. They send out an inspector to have a look at the environment. And then at the end of the rehabilitation process, you get given a certificate to show the area has been rehabilitated. They couldn't produce any of that. You see, that in itself was illegal as well. Them just going and doing, you know. So besides the using wrong and listed activity, they also did that, Chair.
And what was the impact of what they were doing?
Well, the impact is quite serious, because once you build a coffer dam using material that you shouldn't use, you then, you know, the sea has its own self-cleansing way. So the transport, the sediments are here, the sea, the waves and all that transport the sediments. So all that was stopped. And then you find that it also damages the ecosystem there, you know, that exists. So it's quite damaging.
And as you say, it still hasn't been rehabilitated.
No.
At the time.
At the time when I was there.
Okay. Now we move on page 83 to the detail of the appointment of SSI. Page 83.
Okay.
Yes. So you conducted this investigation into the appointment of SSI, who were going to market and sell all the diamonds
Yes.
that were mined in the area by the PSJV.
That's correct.
Yes.
So you want me to? Okay, the first appointment of SSI, what we did was, we then reviewed the procurement process, which was very important, the manner in which they were appointed. Now, we found that the procurement process for the appointment of a service provider to sell and market the rough diamonds was ostensibly manipulated to favor Scarlet Sky. And I'll explain this, Chair. SSI was essentially a shelf company when they first submitted the expression of interest. The director at that time was Hazel Emmon, who was a standing director, and the two directors, Daniel Nathan and Kubota Moodley, were only appointed weeks later. So at the time when they submitted the expression of interest, the supporting documents misrepresented Nathan and Moodley as directors. So this was the first issue that we had. The second issue that we have, Chair, a minimum requirement for the bidder was you needed to have a license to sell rough diamonds. It's a statutory requirement in terms of the Diamond Act. Now, Scarlet Sky Investments did not have a license. So they should have been disqualified right at the beginning. And then the bid evaluation and shortlisting was outsourced to a company called Cabero Advisory Services. Now, Cabero Advisory Services is an external service provider. Now, the unanimous resolution does make reference and alludes to the PFMA and the way the procurement should be run. Even though the Alexco is a Schedule 2 entity, and the PSJV was also considered a Schedule 2, you need to formulate your own policy. It's like Transnet and ESCOM, they are all Schedule 2. You are allowed to formulate your own policy, okay? However, they did not have a policy specifically for SCM. So the Treasury prescripts applied. So in terms of the prescripts, you need to have a properly appointed BEC made up of staff members and management. You cannot have an external party doing the evaluation and the shortlist. You can bring them in as advisors, Chair, or technical advisors, because there are some technical issues. So this was an irregularity that we uncovered. Okay.
The non-compliance by SSI with one of the minimum requirements, namely being in possession of a license, that could not have been an oversight on the part of those who were supposed to disqualify them.
Yes, it could not have been, because it's one of the main requirements.
Because the first thing you do is, do they meet the minimum requirements? Now, in your investigation, did you confront the person who was supposed to establish whether SSI met this requirement? And if you confronted them, what was their explanation?
Chair, firstly, Cabero Advisory Services, who did the evaluation, actually allocated 0 points to Scarlet Sky for not having a license.
Okay.
Okay. So, this was disregarded by the tender committee.
So it's the tender committee that was supposed to pick this up?
Yes.
Or at least they should have given effect to the 0.
Yes, they should have, and they didn't give them 0.
Yes.
They gave them the full 5 points. And so this is where the discrepancies came about.
Yes, but what I'm asking is whether you were able, as the investigators, to confront the tender committee, the chairperson or whoever, to say, how could you
Okay, Chair,
not have disqualified SSI? What's your explanation for this?
These were former board members, and we were unable to contact them. So we didn't confront them. But we did speak to the executive management team and to understand why this happened.
Yes.
Okay. So, but they also were excluded from the process, and they couldn't.
You know, there is a tendency sometimes with investigators that just because somebody is no longer employed by the entity, then they don't follow them Why couldn't you get hold of them? You couldn't get hold of even one member of the tender committee, former member, to say, tell us what's your explanation, or send them a letter saying, we are investigating, we have been mandated to investigate, and this is what seems to have happened here, and you were part of the tender committee, and it seems you should have picked this up, and you didn't disqualify this. What's your explanation for that? Because we may make an adverse finding about you and the tender committee. What's your explanation? Give us your explanation by such and such a date.
No, we didn't, Chair. We also had tight deadlines and time constraints. They wanted the report. So, I mean, there were a number of other issues that we wanted to follow up, but unfortunately couldn't.
Well, it's a pity you didn't do that because, I mean, you did have 3 months, and if necessary, you could have told the Department of Public Enterprises that you needed more time because this is quite crucial. Because you have a situation where your investigations reveal that members of the tender committee failed to disqualify an entity that should obviously have been disqualified. You need an explanation why they failed to do that, because they could not have not seen that the SSI did not have a license, because their job would have been to find out, do you meet these minimum requirements? Did they ask that question? And what was the answer? Because it may mean that they were part of corruption. And that's quite something serious. And you don't want to reach that conclusion without giving those people an opportunity to give an explanation for their strange conduct. You understand that? And it enriches your report if you have confronted those people and you are able to say in your report, after we picked this up, we approached the tender committee and asked them, gave them an opportunity to explain. And this is the explanation they've given. We think this explanation is nonsense, or they failed to give an explanation, and we think they failed to give it because they have none. You understand that? Then your report has more value than if you leave them out.
Chair, could I say something? Thank you, Chair.
Okay,
I hear what you are saying. I think the next point that I was going to raise, Chair, was the tender committee recommended the appointment of Scarlet Sky. However, they gave a condition. They said, we will recommend the appointment provided a due diligence is conducted by the CEO, Carstens, who was also on the board. Now, Carstens then informed the board that he had conducted the due diligence. A due diligence would have entailed also confirming the legality of the license. Okay? Now, Carstens misrepresented to the board that he had conducted the due diligence. And on that basis, they were appointed. So we had interviewed Carstens about the due diligence. He says he's done it. However, the company secretary informed us that no due diligence was done. And he wrote an email saying that he has done the due diligence. So we looked at it from that point of view as well.
But if you have done a due diligence, wouldn't there be a report?
Yes, there should be, because we want to know what you've...
Yeah, and if he said he did it, did you ask for the report? Where is your report?
Yes, we asked. For months we asked the report repeatedly. They had to eventually admit that no due diligence was done.
He ultimately admitted.
Well, no, the company secretary.
Yes.
Because he still admitted.
Yes.
He still maintained that he had done a due diligence.
Yes. Okay, all right.
Thank you, Chair. I think it's an opportune moment.
Yes, let's take, we'll take the tea adjournment. It will be important that I hope the commission investigators have closed the gaps that I'm talking about, that there will be evidence to say the tender committee has been approached about why it did not disqualify SSI. Do we have their affidavits? Do we have an explanation? What is the explanation? Matters like that, there may be other minimum requirements that were not met. I hope that's been taken care of.
Indeed it has.
Yeah.
Thank you,
Okay.
Chair.
We'll take the tea adjournment and we will resume at 22:12. We adjourn.
All rise.
which, as I understand from what you are saying, were full points, knew that there was no license, and therefore in awarding the full points must have been acting fraudulently, because they would not have seen the license, isn't it? Or do I misunderstand something?
No, I agree with you, Chair. There was no license.
Because you can't, either the entity has a license or it doesn't have. It can't be given 60% of the 100 points, because if you have it, it's full points. If you don't have it, it's no points, 0. And therefore, if you award full points without there having been a license, then that must be fraudulent.
Yes, there was no license, Chair. And they should have, and this was one of the discrepancies we find. That's why we did the comparison.
Yes.
And I agree with you.
Yeah, because you can't say we'll give you full points for a license when you haven't seen the license.
Correct.
Yeah. Or at least haven't satisfied yourself that there is a
There is
license.
proof of license, yes.
Yeah, and I guess the way to satisfy yourself is for you to ask the entity to produce the license.
And Chair, we did, if I can say, we did approach the diamond regulator, and the diamond regulator confirmed that
Yes.
SSI does not have a license.
Yes. So that 5 points is most likely fraudulent,
Yes.
the awarding of that. Unless those who awarded come and give an explanation that we can't think of. Yeah, okay.
They have been invited, Chair, to come and give their explanation. We are hoping that they will.
Also, Chair, we found that in the original bid submission, Scarlet Sky Investments had proposed an outright purchasing model. All other bidders had proposed the auction sale pricing model. Now, the outright purchase price pricing model was what was used by the previous service provider. And this caused so much unhappiness. It was a contentious issue. It was actually anathema to management and the contractors. So when they did their presentations to the tender committee, it was changed to the auction sale pricing model. Now you have a bid validity period of 90 days. Within that bid validity period, you can't make changes to the bid. Or if you do make changes, all other bidders must be informed. The company secretary again informed us that they had not informed any bidders that changes were made. Now, allowing SSI to make a crucial change to the bid submission is an unfair and uncompetitive practice. And it is a contravention of the Constitution, Section 217. So we also found this to be a problem. And then lastly, it's the due diligence issue, which I alluded to earlier, that was not conducted. Okay? So in essence, the procurement process was irregular. It appeared to be manipulated to favor SSI, given that all these discrepancies we found.
So you are saying whether we were looking at the license issue or we were looking at the other issues?
Yeah, the license issue was one issue, but there were a number of other, all these issues taken into account shows that there was a manipulation taking.
But of course, the license requirement is a crucial one, because you shouldn't go beyond that stage if you don't have it, because how are you going to do the job?
Correct. Yeah. No, I agree with you, it's a crucial issue.
Somebody as a driver if they don't have a driver's license?
No, you can't do that.
Okay, all right.
Thank you. Now, Mr. Torres, and with your leave, Chair, you are aware that Cabero have prepared a response to these issues, yes?
Yes, I have been informed.
Yes. And you are aware that according to Cabero, they were not instructed to shortlist and they did not shortlist. Can I refer you to page 622?
Is that in the same bundle?
In the same bundle, Chair. It's not the affidavit.
622.
Yes, yes, Chair.
Okay.
Am I correct?
No, a letter?
No, sorry, I'm waiting for the Chair to get to the page.
I am here.
Am I correct that this is the document on which you base your conclusion that they were the ones that shortlisted?
Yes,
And-
this is the document, the letter of appointment.
Yes, and this document that we find on page 622, tell us what it is and just read it for us.
Okay, this is a letter to the Chief Executive of Cabero Advisory Services, and it's the appointment letter to Cabero to evaluate and shortlist the procurement process for the marketing and selling of rough diamonds. And the letter has been signed by Mervyn Carstens, the Chief Executive Officer.
Where did you get this letter?
This is a letter that we got from, in our batch, because we got batch documents from, the company secretary was our main liaison. So she sent us all of these documents. So we got this in our batch from the company secretary.
The company secretary of the PSJV.
Of the PSJV called Reagan Phillips.
So she is the one that when sending you documents that would support the investigation that you were undertaking, included this document.
Yes. What we would also do is we would give her specific documents that we wanted and say we need these documents, and they would send it to us.
What was the point, Ms. Bia, about the letter that you say somebody, is it Cabero or somebody makes?
The affidavit that has been submitted by Cabero but was submitted in short notice and therefore is not yet before the chairperson, in that affidavit they dispute that they were instructed to shortlist. Yes, and
Do they do so on the basis of this letter?
They say that they never received this letter, and I'm taking Mr. Yes.
okay, all right.
Yes. So they dispute that they shortlisted in the first place, and Mr. Torres has just given evidence of the scoring and the fact that they shortlisted. So
Is that a way of saying they were not required to check whether somebody had, the entity had a license?
No, they say that they scored them 0 for that aspect.
Oh,
But
okay.
they are distancing themselves from having ensured that
But
SSI is...
giving them 0 for that aspect should mean they shouldn't proceed to do anything else.
Chair, I don't want to be
You don't want
giving
to be their
evidence.
advocate.
Yes, however, what they say in their affidavit, which
Yeah.
is under oath and they have submitted, is that they only put in the scores, but did not say these are the companies that must be shortlisted. They say they did not have the authority
Okay.
to disqualify.
I'm sure they'll come and explain.
Yes,
Yeah, okay. But it's important for you to put to Mr. Torres what they say about
yes,
their report, yeah.
yes. So do you accept that they did not?
Well, based on this letter, they did do a short listing. And at any rate, when you do the scoring, it's also an automatic shortlisting process, unless, of course, you say a company must be disqualified, and you state it explicitly why. And their scoring already was the shortlisting. Okay.
And surely, by employing Cabero, they expected them to perform a certain, they had to have a certain expertise.
Yes, because you don't employ an external service provider if they don't have the skills and the capabilities to do the job, because you have the skills in-house. So yes, they should have known that SSI had to be disqualified for not having a license.
How many tenders were in fact received?
There were 7 tenders that were reviewed, Chair. There were actually 9 expression of interest submitted, but 2 did not attend the briefing session and did not submit a formal proposal.
So there was an external service provider appointed to evaluate 7 tenders?
7 tenders, correct.
And in your view and in your...
That is the bids, seven bids for a particular tender.
Yes,
Yeah.
for a particular.
Okay.
So in your view, why would they have needed to appoint a service provider for the evaluation of the 7 tenders, if not to shortlist and not to...
Yes, you're quite right, because you have the expertise inside. We have been doing this job for quite some time. And they do the bid evaluation all the time. And then you appoint an external provider. It raises the question, why specifically this service provider? And why were they asked to shortlist? Because normally you just say, do the bid evaluation. The bid evaluation should in itself tell you who goes to the next level. Have they reached the threshold level? Because there could have been a threshold level. I think there was a threshold level, functionality level of 70. So if you don't reach 70, you don't go to the next level. Okay. So you don't. So there must have been a reason. Why?
Were you given an explanation why this was outsourced during your investigation?
What we wanted to know, why, we also found that the company secretary and the other executive members, because they were not involved, could not give us an explanation. So we then asked
But somebody must have taken the decision to outsource. Did you
it was
approach that
Carstens.
person?
Carstens. Now, there were allegations that he had previously, in his previous job, had contact with Cabero Advisory, but we could never confirm it. Okay.
Yes, but what I'm asking is, did you confront him to say, explain why it was justified to outsource this? And did you approach him? Did you provide an explanation? If he did, what was the explanation?
Well, all that he said was they have the necessary expertise and knowledge to do this particular job. And also that they were doing other advisory services for the entity.
I'm sorry, so you did approach him?
Yes, we had an interview with him, a formal interview.
Yes, and his explanation was?
Well, all he said, they have the expertise. They wanted them because they have the expertise.
About the internal expertise. Why not use the internal expertise?
Well,
that's an obvious question you would ask him. Why are you outsourcing? Because we have got the expertise.
well, we questioned because we said by employing external service providers, even if they have the, it's actually fruitless and wasteful expenditure.
Yes, that's why I'm saying it's an obvious question for you to ask, to say,
no.
why are you outsourcing? You've got the expertise. Because the outsourcing, in circumstances where there is in-house expertise, may be an indication of something else. So it's a crucial question and an explanation for that, why it was done in circumstances where there was in-house expertise to do the job, is quite important.
No, I mean, this explanation was that they have the technical ability in terms of the industry as well, and that is why they were appointed, and we left it at there, Chair.
And what did you make of that explanation?
It didn't make sense to us, Chair, because the only technical issue was the license. The rest was, have you met the requirements? The scoring was on issues such as, okay, there was some technical issues, but the scoring was on the criteria was mainly on local development. What are they going to do on that? The pricing model was an important issue. So they could have had, and this is what our argument was. We said, yes, fine. Maybe they could have come in as a technical advisor, because that's what happens all the time. Your BEC don't have all the technical knowledge at times. So why did you not bring them in? He said, no, they were there to do the bid evaluation.
Thank you. And what else did you discover had been done wrong in the procurement process?
In the procurement process?
Yes.
Well, I think I've covered most of the items that were done wrong. It's just to summarize, there was no license. Cabero as an external service provider, there was no compliance in the way they were appointed, because they should have appointed internal staff or have a properly constituted bid evaluation committee. Also, the scoring of the three shortlisted service providers. There were discrepancies. For example, basic discrepancies like all three service providers had, okay, after the changed bid submission of SSI, they all proposed a commission of 1.5%. But two of the service providers were given 3 points and the other one was given 4 points, for the same. So it was, to us, we got the impression, that's why we say we think it was manipulated. They were just giving points to ensure that SSI got the highest points. That was the presentation, after the presentation.
And of course, we have the issue of the due diligence. That was a condition.
Yeah, it was a condition that I think also the subcommittee wanted to protect itself. They had made a recommendation. They then said, based on our recommendation, no, we recommend SSI. However, you need to conduct a due diligence, which was never conducted.
And
That's it.
and when it came to the board and reporting to the board about the due diligence, what
Well,
did you find?
Mervyn Carstens, the CEO, actually wrote an email to board members confirming that he had conducted the due diligence. And based on that, they accepted it and awarded the contract to SSI.
But how could the board just accept his word? One would have expected that they would ask for the report, due diligence report, so that they could evaluate it themselves, see what it says.
Chair, right from the beginning of our investigation, the due diligence report was one of the things that we continuously asked them for. Eventually, right at the end, they confessed and said, the company secretary, actually Reagan Phillips, confessed and said no
Yes.
due diligence was done.
Yes. So the letter that Mr. Cousins wrote to the board, did it say, I've conducted due diligence and this is the outcome thereof, or what did it say?
I'm trying to remember the email. It's such long. But
Yes.
the email said, I've conducted the due diligence.
Yes.
The email did not specify,
Yeah.
what was in the due diligence.
Would that email be part of the annexures to your report?
It should be.
Or you're not sure?
I'm not sure. Chair.
Okay, that can be checked later. You see, it becomes important because we also need to look at the role of boards of these SOEs. How can you simply be told a due diligence has been conducted and you make a decision without seeing the due diligence report? How do you do that?
Correct.
And it turns out there was no due diligence that was done anyway. The question arises, why was there nobody among the board members who said, where is the due diligence report? We want to see it before we make a decision. You see. Did you have access to the minutes of the board meeting where they discussed and made the decision?
Chair would have had, I think, the appointment of where the appointment was made in the board. I'm sure we've got those minutes.
Yeah, okay, all right. It would be important to see what was said, yeah. Okay.
Thank you. And then we move on to the second appointment. But before we get there, what did you find in relation to the expertise, the scoring for the expertise? Did you have any problem?
The scoring?
In relation to the experience and the expertise? Did you have any problem with that?
The experience.
Yes.
Of SSI.
Of SSI. Of SSI, yes.
Well, I think right at the beginning I alluded to the fact that it was a shelf company. So there was no business track record, there was no experience.
Yes.
So they should have got very little.
Yes.
But there were allocated points, and then there were also gaps in their bidding. That is why the criteria was changed as well. Because the pricing model, they didn't have in their first budget. And then there was also beneficiation, the local community. They needed to, there was an aspect where the local community had to be empowered. That was actually removed from the criteria during the presentation stage.
Thank you. Okay, now we can move to the second appointment of SSI.
The second appointment of
What page is that?
It's the very next page, Chair, on page 92. Maybe, I'm sorry, I
When
didn't
you
take
took
you.
us to page 622, are we, is it 623 or
I'm
are we going back?
I'm walking by myself, Chair, and leaving everyone behind.
Yeah, we can see that.
Yes, we are actually
You
back.
need us.
We are back at page 92.
92.
Yes, thank you, Chair.
okay, I've got it here.
Yes.
The second appointment of SSI,
Firstly, I'm sorry to cut you, Mr. Torres. Were you happy with the appointment, or did you also make adverse findings in relation to this appointment?
in our view, the procurement process for the appointment of the service provider to market and sell the rough diamonds was fatally flawed. And we did have adverse findings.
Okay, you are talking about this second tender?
Here's the second tender.
Yes. Now you can go ahead and say what your findings were.
Now, the second tender, the BEC, there was a BEC appointed, and the BEC comprised the executive management team members. So there was a BEC. We then requested the minutes, the scoring of the BEC. It was at this stage when the company secretary, who was also a member of the BEC, admitted to us that they did no evaluation at all. Their only job was to ensure that there's compliance with the requirements. Now, this is the requirements such as, is there a tender certificate? Is there a BE certificate? Now, this is an administrative job that is usually done by supply chain management staff. It should not be done by the executive team. So the BEC in itself was, you could say, a hoax in a sense, because they were appointed, but to do what? Because your responsibility as a BEC is to do evaluations. So they did no evaluation, and that to us was a problem. Already, right from the start, there were problems with the procurement process.
Did the company's admission, was the company's admission that no evaluation was done in writing?
Well, what she did was said, they had no records that an evaluation had been done. And that is why it was a problem even to get minutes, documents. In fact, there was even a problem in us finding out the number of submissions admitted.
Yes, but my question is whether whatever he said, whether that was in writing, namely whether he said there was no evaluation done or whether he said there were no records indicating that evaluations were done. What he told you, was it in writing? Did he sign a statement or do an affidavit? Did he send a letter? Or was it just verbal?
No, we had an interview with her.
Yes.
On this particular, on a number of other issues.
Yes.
I'm just trying to recall, Chair, but we did, on this particular issue, it says that normally when they get appointed as BEC, they do evaluations. But I can't recall whether she informed us whether it was an instruction. And I think that is what you want to know, am I right, Chair? That she was instructed
Yes.
not to do an evaluation.
Would your interview with him have been recorded by any chance?
No.
It would not have been recorded because it's quite important information. So I would have imagined that if you did not record the interview, you would have asked him to do an affidavit or at least minimum a statement to say, give us a statement that tells us exactly what you have just told us in this interview. Did you do that?
No, we didn't.
Why not? It's such an important thing.
Chair,
I mean, evaluation was important. It should have been done. Here is the company secretary either telling you no evaluation was done or we were instructed not to do it, or there are simply no records indicating that this was done. So now you are conducting an important investigation. How do you not secure either a statement or an affidavit from this person giving you this information?
Chair, I can't recall us asking her for an affidavit, but I agree with you, it's an important point. Again, Chair, under the circumstances, in fact, we thought we'd get a second opportunity to continue and close the gaps, but we never got to a second appointment.
Yeah, it's unsatisfactory. It's unsatisfactory. I mean, this is very important. Now, somebody tells you very important information, you are investigating, you are going to compile a report, give it to the Department of Public Enterprises, and he tells you crucial information, you don't ensure that it's in writing, to say the least, or it's an affidavit, or it's recorded. It's unsatisfactory. Ms. Bia, continue.
Thank you. Maybe if I can assist you, Mr. Torres, on page 146.
100?
46, 146. This is the section where you detail the content of the interview. You detail the date of the interview with Ms. Phillips, and you set out in the report still what she informed you. Are you with me on page 146?
Yes, I am.
Okay. So you'll see that in paragraph 17.5.4, you say, on 4 October 2019, we interviewed Ms. Reagan Phillips, the company secretary of the PSJV, and she informed us that she's an admitted attorney who's done postgraduate studies at Stellenbosch University. And then 3 bullet points down.
Okay.
Can you see what you wrote there as a recorder of your consultation?
Okay.
Can you read that for us? So the 4th bullet point.
It's the 4th bullet point.
Yes.
Yeah. Appointed as, this is the interview with Phillips. Phillips informed as follows. Appointed as part of the BEC for the procurement process involving the tender for marketing and selling of rough diamonds. The committee did not do any scoring for the evaluation purposes, only checked compliance to the minimum requirements.
Did you ask her why the evaluation was not done, or the scoring for evaluation purposes was not done?
Chair, I think I don't see it here. I can't recall.
But it's such an obvious question to ask if you are investigating. And this is what, company secretary?
Yeah, the company
Secretary is an important official in the company, and if I recall correctly, part of their job is to ensure compliance with legislation and so on. So she sits on a committee which was supposed to conduct an evaluation, and she tells you they didn't do the evaluation, because if they didn't score, that means they didn't do the evaluation. Most obvious question to ask is, why not? That's what you were about as a committee. That was your job. Why didn't you do the job?
In fact, we raised the question that the BEC, that's their job. But she said that's all they did. They were not given any other information to work on.
Yeah, did you ask her why were you not given? Who was supposed to give information? Why were you not given information?
Chair, the questions, we raised a number of questions. I must admit that at times they were evasive, you know, and because we also had time constraints. We were in Cape Town. We had to conduct, unfortunately, we were in Port Nolloth when there was a dust storm, and we could not conduct any interviews. So we had to reschedule because it's quite a drive to Uppington, because you have to drive to Uppington, 700 km, then get a flight back to Joburg. So it's an issue to get there. So I think the time constraints were also.
Yeah, but you had 3 months to do this, and you are interviewing the company secretary. And she tells you, I was part of the committee that was supposed to do an evaluation. We didn't do an evaluation. Obviously, you must probe further to find out why. Why didn't you do your job as a committee? To find out whether they were instructed by anybody not to do the job. If they were instructed, who instructed them? Why did they comply with that instruction? Was that instruction lawful? And so, or were they part of a certain agenda, or were they not part of an agenda? And you can't get an answer to those questions if you don't ask the relevant questions. You see, it dilutes the significance of your report if you don't ask questions that should have been asked.
I agree, Chair.
I see here on the 4th bullet point, it says, you recorded that she said they only checked compliance to the minimum requirements. Is that right?
It's right, and I do say.
And did she say that they found that there was compliance with the minimum requirements? Did she tell you that? Or what did she say was their finding about?
There was compliance to the minimum requirements.
Sorry?
There was compliance to the minimum requirements.
Yes. Is that because Scarlett now did have a license or what?
Well, they were using the license of a related company.
Is that allowed?
It's not allowed. I mean, you must have your own license.
So why did you not make an issue on that? Why didn't you raise that with her to say?
Well,
if Scarlett didn't have a license, then they didn't meet the requirements. They couldn't use somebody else's license.
Chair, I hear what you say, but it says the requirements that they were given, all the requirements were met. Now, we don't have a written document stipulating what requirements were put down.
Did you ask for them?
So, yeah, but there was no, we asked for all of that. There were no
But
documents
who would have decided on the requirements?
Well, there are essentially, when you submit, there are certain requirements that you
Yes,
need.
yes.
Like your BID, your tax certificate, your BE certificate.
Yes.
The BID document must be properly signed.
Yes,
Those
but I'm
basic
saying
issues.
somebody within the company would say, for this tender, these are going to be the minimum requirements. Isn't it?
No. There was no document stipulating what were the minimum requirements.
Yeah, so how did they know what the minimum requirements are that she is talking about here?
Well, we assumed that it was just the normal administrative requirements. You know, having a tender, a tax clearance certificate, a BE certificate, submission of documents.
Yeah, but how could you assume? This is something you are supposed to satisfy yourself about. If you are asked to investigate whether a company was awarded a particular contract lawfully, obviously you go back to the start to say, okay, when the request for proposals was issued, what requirements were there? Who was eligible to make a proposal? Did this company meet those requirements and take it from there?
Well, Chair, at this stage already we knew it's a sham because there were no documents available. Because normally, even the supply chain, they would have a document like your tender requirements, where these are the requirements, and it's a tick exercise, really. You're quite right, Chair, it's a tick exercise. But there was nothing.
But does your report say that there were
Yes,
no such documents?
We asked for it. It does say
It does say that.
that we asked for all the minutes and everything.
But are you saying at page 146 of the report that Ms. Phillips said they checked compliance with the minimum requirements and found that there was compliance? Is that what you record her as having said?
I said only check compliance to minimum requirements.
Yes.
And
So what I'm asking, what that means, because it says only checked. Now, you can check and find that there was no compliance with the minimum requirements. You can check and find that there was compliance. So this doesn't tell me which one. So I'm asking you, did she say they checked as the committee whether there had been compliance with the minimum requirements and found that there had been compliance with the minimum requirements? Or
Yes,
do you
this-
not remember?
yes, there was compliance, but we needed also the documents, and that was not available.
Yes.
Because to us that, it's again, yes, there was compliance. What did you check? They couldn't give us. And I think this is one of our requirements that we wanted, the compliance checklist, which also we didn't get.
But your report in regard to your interview of her doesn't, unless it's dealt with elsewhere, doesn't reveal that you raise these queries unless you deal with that somewhere else. Because you are interviewing the company secretary. She says we checked compliance with the minimum requirements. And obviously you have to say, what did you find? If she said there was compliance, you say, what were the minimum requirements? Where are the documents that say those were the minimum requirements? That doesn't appear in the report.
Yes.
And yet it's quite something important, because how can she say there was compliance if she can't produce the document that tells you what those requirements were? Can you see where my problem is?
No, I hear you and I agree.
And I would have expected you to want to satisfy yourself on this because you want to be able in your report to say, was she right in saying there was compliance with the minimum requirements or not? You see. In your report, did you deal with whether she was right about that?
The BEC, I only deal with the BEC issue and what she responded to. The focus was because after there was a short listing done. And the short listing, they also again, like the first procurement, presented to the tender committee. Okay. Now, also again, our problem was, how did they shortlist if there was no evaluation done? There was no documents, nothing. In fact, the procurement process for the second appointment was a sham.
Yeah, but at least this page 146 doesn't reflect that you probed issues that you were supposed to probe. She seems to tell you she checked compliance with the minimum requirements, and that seems to be left at that.
Yeah. Chair, I think if you look at the issues, 3 months might seem a long time, but it's a short time of investigation.
Yes, but just this one person, you don't need, just an hour with this person, you say, okay, what were the minimum requirements? And
Well,
you
we
say, these were the minimum requirements. Where are you basing that on? Where is the document that told the bidders these were the requirements? Where do you get that from? How can you say there was compliance if the bidders were not told what the requirements were?
Chair also must understand that this also served as a preliminary investigation. We had expected to then have another phase where we would probe certain aspects.
Yes, but these are the basic minimums. Why must those be dealt with by another investigation? These are the first things you look at, and then they don't need a lot of time. You see, why must the Department of Public Enterprises have to either appoint you or appoint somebody else to do another investigation after they have paid whatever they paid for your report, when this can be established very quickly? Okay, Ms. Bia, continue.
Mr. Torres, on page 92, you set out on 12.1.2 what were the minimum requirements. On
What page?
92, Chair. In paragraph 12.1.2.
No, on 92.
Yes.
Oh, I'm looking,
92
sorry,
in
I'm
black.
looking here. The wrong page.
12.1.2, Chair.
Okay.
You set out the minimum requirements for this second bid. And
12.1.2 doesn't set out the minimum requirements. It sets out what was considered to be minimum requirements. I don't know considered by whom.
well, Chair, I'm still taking Mr. Torres to the document that supports, because I think some of it he might have forgotten, but he makes reference to it.
Okay.
Yes. So, if I can take you very, very far to page 640 of the same document. (640). In fact, that identifies the number of the exhibit only. Now, the document that appears there, it's called the tender. It says marketing. Oh, you're not there yet. Are you not there yet?
Pardon?
You're not there yet.
I am, it's 642, you say?
Yes, 641.
641.
Yes.
Yes, I am there.
So what is this document?
It says the marketing, post-extraction treatment, processing and beneficiation of diamonds.
Yes, but what is this document?
Pardon?
What is this document?
It's a request for proposals.
Okay. And it's the request for proposals for the same contract we are talking about?
That's correct.
Okay. Now, if I can take you to page 655 of that same document.
Yes.
Do you see in the middle of the page where it's in bold? 655.
Oh, 655.
Yes.
I've got it.
Can you see in the middle of the page? This is still the same document. Can you confirm that it's still the same document that we've just identified?
That's correct.
Okay. Can you see the heading in bold that says Section 2, detailed terms of reference? In bold in the middle of the page.
Yes, I do see it.
Okay. Can you see that subparagraph? And immediately below that it says, as a minimum requirement, proposals must demonstrate the bidder's ability to.
Okay, I'm there.
Okay. Do you not think this is where you got the minimum requirements?
I think
That you
because
reflect-
It's exactly the same as the report. Almost.
Yes, it is almost, it's not everything. It's this document, the items listed on this page, there's only 4 of them, so it's A to D, and then you on page 92, in addition to what they have put in, you include a BEE level and you include the tax clearance. But in terms of the substance, this is exactly the
This is
same.
Yes.
So,
Well, what was the page on the other one which has got considered?
92,
92.
yes. We can go line by line.
So now, Mr. Torres, how does your evidence that there were no documents setting out the minimum requirements
Well,
gets reconciled with this document that sets out at page 655 the minimum requirements?
no, I've got the minimum requirements, but I think I'm talking about the compliance check. There was no documents showing which compliance check was done. Because
Well,
we needed the minutes.
you and I were talking about, you remember the page in your report where you recorded what the company secretary said in the interview you had with her. And she had said, according to that report, only checked compliance with minimum requirements. And then I asked the question, was there did she say there was compliance with the minimum requirements? Because checking compliance with minimum requirements doesn't tell me whether there was compliance or there was no compliance. So we then got to talking about what were the minimum requirements. That's when you said no documents were provided to you that set out what the minimum requirements, as I understood your evidence.
Based on the report, there were, the minimum requirements were there, Chair.
Sorry?
Based on the report, the minimum requirements were there.
Yeah, no, I now know that they were there, but I understood you to say you asked for documents that set out the minimum requirements and you were not provided with them. That's how I understood your evidence. Did I misunderstand your evidence?
Well, we did ask for documents that were not given, the minutes, even the compliance check, because she must have signed the compliance checklist to say that I've done this list and this is, that we didn't get. But the compliance, the minimum requirements as specified in the terms of reference, it's part of our exhibit, annexes.
Ms. Sibia, how long do you need with this witness?
Chair, I think 1 hour. Yes, Chair. I don't want to underestimate the time as we are known to do.
Well, we still have about 30 minutes before we get to 1 o'clock. See how much you use that 30 minutes. I'm not sure that we need an hour. Continue.
Thank you, Chair. Thank you. Now we move on to the issue of the marine contractors.
Okay.
If I understand correctly, these were the people that had complained to the DPE, and this related to the same soured relationship that had been identified and had been part of the reason that you were appointed to conduct this investigation. I'm taking you to page 98.
98?
Yes.
I'm there. Chair.
Okay, yes. So, what did you investigate and what did you find, as briefly as you can? What was the complaint that you were investigating?
On the evaluation process itself, we found no adverse findings. There was a properly constituted BEC, also made up of the executive team. So there were no issues with that. There was the BEC stroke tender committee recommended 8 out of the 19 bids. There were 2 bids, the beach mining activity, and there was the shallow water activity, marine activity. So the beach mining activity, there were 19 submissions. 8 bids were recommended for award. The shallow water marine tender, there were 66 bids submitted. 51 bids were recommended for appointment. Included in the 51 bids, you had 4 contractors that were subsequently excluded from the procurement process by the board. Okay. Now, the board held, and the 4 contractors that were excluded were Ocean Diggers, Malakaza, PL Marine, and Repsol. These were the 4 contractors. Now, this is all related to the relationship that existed between the contractors on the one hand, the executive management and board on the one hand. It was a hostile and unfriendly relationship. And the board then decided, they had a special meeting held where they discussed the appointment of these 4 contractors. At this meeting, the board decided to exclude them from the procurement process on the basis that they were disruptive, they were abusive, they had damaged the reputation of the board and the executive management. So on this basis, they were excluded. However, the process was not followed. Even because in terms of the unanimous resolution, it's quite explicit. It says the executive management can recommend to the board the appointment of an independent contractor. If the board disagrees and rejects the recommendation, it must be referred back to the executive management for reconsideration. The executive management then referred the matter back to the board. And if the board can't refuse or reject, the second time around they can't reject the recommendation of the executive team, provided that the organization will be financially prejudiced. Now, the exclusion was not based on financial prejudice. It was because of the type of relationship that existed. So the board acted improperly in rejecting the award of the 4 contractors.
Ms. Bia, remember that his report is before me, and
Yes.
their findings are there. Whatever recommendations are there, I think what's more important for you to look at the important findings that you want to bring to my attention, let him deal with them and the basis for those findings and take it from there. Otherwise, most of what he says is in the report and one can read it, but it's important to see the basis for certain
Yes.
findings.
Yes.
Yeah, and question him on the basis or the process of conducting the investigation.
Thank you, Chair. I'll do so. Now, Chair, this is not an indication that I'm not following what the Chair has said, but I'm just going to move to the next page.
No,
of
that's fine.
The report, because it's the next topic.
That's fine, yeah.
Thank you, Chair. On page 108, it could be that I'm saying it's the next page and maybe I've left you behind again. But I'm now asking us to go to page 108.
108.
Yes,
Okay.
That 108.
yes, 108. Now, this was one of the more contentious issues, am I correct?
Yes, it was the valuation and pricing were contentious issues.
Yes. Okay. Tell us what you were asked to check and the process that you followed before you reached your finding,
Okay.
as briefly as you can.
There were complaints that Chair, there were complaints that the diamonds were being undervalued and that no proper valuation process was being done. Now, the way they value the diamonds, they call it the 4 C's method. It's your carat, your color, the clarity, and the cut. Now, there was a problem. There are 2 valuations done. At the processing plant, you would have the PSJV. They've got a diamond valuator who then do the valuation there. Now, the valuation being done by the PSJ valuator was done purely using carat quantities. The other C's were not used. And we inquired why. And according to Customs, who was the CEO, he said no, the evaluator at that stage had no skills. She could only do carat valuation. So that was the reason they gave. And then there's another valuation done by SSI. They get an independent valuator to do a valuation. There were also complaints about the valuation done by SSI. What we did with SSI, we then requested them to give us the certificate of valuation. Because each diamond, there's a certificate issued. Because that would give us more details on how it was done, what carat was there, the cut, the clarity, and all that. They could not give us any certificates. I mean, they promised, but they never gave us. And then we also did a comparison, because it was very difficult now to do the valuation based on, because they didn't give us any information. So we were forced to then do a pricing, to get the pricing index, the Minsky pricing index, and also the second index was Bloomberg. Now, it's not ideal to use this index because the pricing is averaged and a mixed bag of diamonds get used. So your pricing would also be lower. However, we found that there were big discrepancies, that the pricing was much lower than the Bloomberg and the Zimnisky prices. And in fact, undervaluation, so there was a big problem there with the valuation. And then, of course, also, there was no compliance with the contractual terms of the agreement. Contractual terms are very clear that 5% of the diamonds must be sold to a local buyer for beneficiation purposes. The 10% must be sold to the state diamond trader in terms of the Diamond Act. And then the 85% had to be purchased by buyers through an auction sale. Now, when we looked at the after-sales report and the invoices, we found that, firstly, it depicted that 85% of the diamonds were being sold to Scarlet Sky. And in terms of the contract, it should be through an auction process. We then requested the names of the bidders because they insisted that they hold auctions. So we said, okay, then why? You should not be putting your name on the after-sales report. The response was, it's classified information and we can't reveal it. We then insisted that, no, PSJV is your client. It's their information, right? And we're doing the investigation. They said that we never got that information because we needed to know who are the buyers. We also needed to know how much was sold and to which buyer. It's very important. So that was a big problem to us. So that is why we were also forced to do the Zimnisky Bloomberg valuation. We then found that when we looked at the 10% and the 5% sold, we found that it was based on carats, carat quantities. Now, in terms of the contract, it should be based on value and not on carat quantities. So we did a comparison, and then we found that the way they did the pricing, they actually undersold to the state diamond trader by 60 million. And they also undersold the 5% locally by 38 million. There was a dispute with them all the time because they insisted it's done on carats and quantities and we are misreading the contract. And even the regulator agreed with us it should be on sales value. And the Act says as well, because it's a statutory requirement that 10% gets sold, it's on sales value. So there was definitely, it was a means of selling poor quality diamonds to locally. Okay.
Mr. Torres, when you speak about the 60 million amount,
Yes.
that was the value of the undersales, over what period?
We're talking about since their first appointment, which was the beginning of 2015, right up to the time that we were appointed, I think just before our appointment.
Okay. And your appointment was in 2019, so that would be over a period of 4 years.
Yeah, I think.
Yes, and then you also, with regards to beneficiation, you also had a problem?
Yes, we had a problem. That's the 5% that I'm talking about. 5% should have been sold. There were two problems. Firstly, the 5% was based on quantities and not on value. So it also was undervalued and undersold. The second issue was that the 5% was sold to a related company, which was Daniel Nathan, owned by one of the directors. Now, this is a conflict of interest. And at times, they sold it to another company called Geddes, which was also in the same premises where they were situated. And so they didn't see it as a problem, but we saw it as a problem.
Without a license, could they in fact be selling to anyone?
You know, eventually, because they could not provide us with all the information, of the bidders, the valuation certificate. They could not tell us how much was sold to which bidder. There was a suspicion because we even confronted the CFO, and we said, you verified the veracity of these documents and you made a payment, commission payment to SSI. Why are you not, why didn't you get the info, why didn't you ask for more information? Supporting documents before you sign off and pay. According to him, no. We sold the SSI are the buyers of the diamonds. I asked him then, did you read the agreement? The agreement is explicit. It says SSI only facilitate the buying. They should not be buying. He said he never read the agreement. And that to me was also another, it's a problem. Because how are you CFO? You verify payments and you don't, because you're supposed to check the veracity. Check if these people have been properly appointed. Is an agreement in place? What does the agreement say? So we had all these problems.
Thank you. And what did you find in relation to the relationship? I'm moving to the next
The relationship.
topic. Yes, the relationship between the marine contractors and the JV.
There was a hostile and unfriendly relationship. In fact, the trust relationship had broken down. And according to executive management, they were upset because their concerns were raised in public. They were not approached. However, the contractors met with the executive team a number of times, raised the concerns to them, it was ignored, and as a last resort, they then went public. And there are certain concerns that they raised, which we investigated. For example, they raised the concern that the diamond gravel processing plant was operating inefficiently. And they were particularly worried about the security controls, of the diamond gravel. Because there are various stages of extraction that's used in the plant. We did a physical walk through the plant. And the first stage is what they call density media separation. Diamonds are supposed to be one of the heaviest minerals. So they use this to separate the heavier material from the lighter material. Now they complained that they were not allowed to use their own tracers, density tracers. Now the density tracers would then test the density. We then approached and asked the operations manager why they were not allowed to use the tracers. According to the operations manager, who was Jerome Kluti at that stage, there is no guarantee that the tracers have been tested. This was his excuse. And we found this not acceptable because a certificate, you could always ask the contractor to give you a certificate that the tracer has been tested. And that is what we told him. And then the second point on the tracers was that they were not told the number of tracers that gets put into the separate piles. And this was an issue for them because then you don't know what's happening. Now, according to Jerome, no, the contractors are lying. We've got records showing that they acknowledge how many tracers are placed in the heaps and how many tracers are taken out of the heaps. We then asked for the records showing that the contractors had signed. They could not provide us with the records. Okay? So we found that the complaint and the issue raised on the tracers was a valid one. And then there was also the issue of the security control issue in transporting the diamond heaps from the X-ray room to what they call the glove compartment. This is a glass container. And because they use a container that's like, it's a metal milk-like container. It looks like an old metal container. They use that to transport the gravel, diamond gravels, and that's secure. However, because of insufficient numbers of containers, they then use a sack-like bag. And the contractors were very unhappy with it because the sack-like bag was of a poor quality, and you could make a hole in this sack-like bag and actually remove diamond gravel and then close the hole as well. So they were very unhappy. Again, we questioned the operations manager about this. He admitted that they do use the sack-like bag and they don't have sufficient containers. Okay. So this was an issue. And then the other issues that they had was the reclamation of the tailings. Now the tailings are essentially your residue. You know, it's like your mine dumps that we have in Johannesburg. It's a residue, so it's a dump that they have. Now, the special extraction process that they use to retrieve diamonds from the dumps. Now, they complained that they were not given, they needed to share. In terms of their contract, it's called tailings. They need to share equally the proceeds derived from the tailings. Now, we then questioned the CEO about it. The CEO said, yes, they do qualify to share in the table tailings, but not the stockpile tailings. The agreement does not make a distinction between table tailings and stockpile tailings. The agreement only says tailings. That's all it says. So we found this questionable, and also we did not. It was not part of our brief to investigate the appointment of EBICO that was doing the extraction of the tailings. So there was also a complaint that they had been appointed to do this, and that Carsten's wife was a business partner of EBICO.
And EBICO are the company that were getting the balance of the tailings.
No, EBICO was appointed to do the extraction of the diamonds in the tailings.
Yes, so the tailings that were supposed to be shared.
Yes, correct.
Okay, thank you. Now I will move you to the last issue that I'm going to deal with, and that's in relation to the governance and management issues. You are on page 131.
Okay.
Now, you found that of the boards, of the committees of the board that were in place, there was a committee that was not authorized to be a committee that's part of them, and that's the tender committee. Tell us what irregularities or what you were unhappy about in relation to the tender committee.
The tender committee was a committee comprising board members. It was a subcommittee of the board. Now, the unanimous resolution stipulated the formation of certain subcommittees. Now, the role of the board, the board has an oversight responsibility. They should not get involved in operational matters. The tender committee, the work of a tender committee, what they did here is similar to what a bid adjudication committee will do. Board does not get involved in operational matters. So we had an issue with that. And there was a good reason why it was not suggested in the unanimous resolution.
Okay. Those are the questions that I have, Chair, for this witness.
What you may have forgotten to do is to give Mr. Torres the opportunity to give his background, his educational, professional background and experience.
Thank you, Chair.
Will you take care of that?
Yes, thank you. Mr. Torres, I only asked you if you were still an executive director at Gobodo, and I didn't deal with that. So can you tell us your experience
Okay, Chair.
and your qualifications?
I've got a BCom honors degree in auditing, tax and accounting. I've also done my articles what was then in the 80s known as Piet Mawick, it's now known as KPMG. I am a registered accountant with SAIPA. I am also a certified fraud examiner with the international body and the local body. I have almost 40 years experience in financial management, external auditing, forensic accounting, due diligence investigations. I've done and conducted audits and, well, when I was in the private sector, I did audits on the banks. In the public sector, clients included the Reserve Bank, or Ponzi schemes that we did. We also did the first FICA audit of the 5 big banks. National Treasury was one of our big clients as well. And then we've done across the public spectrum. We've done state entities, provincial departments, municipalities. And then my other experience is working as a financial manager. I've also sat on audit committees, served as audit chair as well. So that's my background.
Okay.
Thank you, Chair.
Okay, thank you very much, Mr. Torres, for coming to give evidence. You may be asked to come back if we feel there is a need, but thank you very much. You are now excused. I don't think anybody wishes to do anything, so yeah, you are excused. In the afternoon, Ms. Bia, who will you be calling?
I will be calling Mr. Gavin Creighton.
Okay, all right. We'll take the lunch adjournment now and we'll resume at 2 o'clock. We adjourn.
All right. Okay.
This is our
It's that bunch as well.